Welcome back to the Law&Crime Network. My name is Bob Bianchi. I'll be taking it from 12 to 3, and you guys know we're handling gavel to gavel, and we got a lot on the plate. Okay, well, let me bring in my friend, Gene Rossi, who's a legal analyst here at the Law&Crime Network. Like I said to you before, it's the best of the best here, 3 decades with the DOJ. They actually have a Gene Rossi war room. He's taught over 1,000 prosecutors, had over 100 trials, a prolific litigator, a great legal mind. Gene, welcome back. Good to be back on with you again.
It's actually called DOD, Department of Gene.
Well, it should be. In fact, I think they may be considering, we got to talk to Dan Abrams about maybe renaming the network here. But you know, hey, Gene, you know, I always used to say, you know, when you're going to do cocaine with your dad, and you know, and he decides to fall out and has like a heart attack and dies, that, you know, you really got this like difficult option in your mind. You know, do I call 911 and see if I can have him resuscitated, or say that, hey, those are his drugs, I had nothing to do with it, or chop his body up? It's a tough call, don't you think?
Yes, and I've learned in my entire career that the facts of the case are whatever a jury believes. And when he took the stand many weeks ago, when we were watching his testimony on your show, I was going, there's no way a jury's going to believe this. They believed it. They believed it.
Well, and when you say they believed it, what exactly are you referring to that they believed?
They believed that he was so high, so paranoid, so scared because of drugs and booze and other things, that when his father allegedly died from cocaine or a heart attack, he panicked and concluded the only way I'm going to get out of this is to chop up my dad's body and put it somewhere else. Yeah, and they believed he didn't kill him.
Yeah, and it really was, you know, we use this, you know, we questioned this, Gene, when we were talking about whether you should take the stand or not. And we often use the Laquan McDonald case as our example of what a horror it was when that cop took the stand. Both substantively, his testimony was bad. His whole demeanor was bad. He seemed like he was a deer in the headlights. But this guy actually got up there. His demeanor was pretty good. He seemed like a pretty good witness. But when you get to the substance of it, like you said, it ultimately depends on the common sense of the jurors as to, do I believe this guy or don't I? But it was a big risk that paid off for him.
Yes, and because I'm personally going through this right now with a client, when you determine whether to put your client on the stand, he or she, you have to sort of test drive that person in prep session and things like that, and try to place yourself in the jury's shoes. If he's in that witness box like he is right now, what's the jury going to think about him? In the case you just mentioned, Laquan McDonald, I guarantee you they probably concluded it's a close call. The jury may not like him. The defense attorneys in this case, Scandirito, probably said, you know what? I think this guy is going to come across pretty good, and he did.
Right, right. Well, you know, he had to get past the biggest point that you mentioned, Gene, is it reasonable for him to dispose of this body in a really heinous way, up close and personal, by dismembering and chopping him up? Let's take a listen to how he handled that on the witness stand. Okay, so there you have it. I mean, he's taking the stand there, Gene. He's explaining how and why it was that he dismembered the body. I guess you could say that there are other ways to dispose of the body without having going through the grueling and gruesome details of decapitating and cutting your father's body up in the manner in which he did. But like you indicated before, the jury believed him. They certainly is believable in the manner in which he's describing how he did it, but they went much further and said, we believe that you didn't murder him, that he had this medical event. And Gene, now he faces sentencing for the equivalent of desecration of human remains. So what are your overall thoughts of his testimony, and what do you predict would be the kind of sentencing a judge would give in these circumstances?
All right, I'll get to the sentencing in a moment. You cannot conclude anything other than the jury was very impressed with his testimony. And watching that, you know, Monday morning quarterbacks never throw an interception. I got to say, he comes across as, I'm not being facetious, thoughtful, rational, and respectful, given what he did. And I think the jury believed everything he said, or most of it. And I got to give kudos to the defense attorneys. They picked a phenomenal jury, and they rolled the dice. They got the conclusion. Now let's do the sentencing.
But Gene, before you get to the sentencing, to your
Yeah.
point though, and that is a good point. This wasn't just a trial to one juror. In order for him to be found not guilty of the murder, all 12 jurors were convinced.
Which makes it even more remarkable. I could see a hung jury, but he hit a home run with the bases loaded in the bottom of the ninth, and I got to give the defense attorneys credit. But going to the sentencing, I suspect that the judge is going to respect the verdict, of course, but I don't think the judge is going to be very kind to this person at the sentencing. I would suspect that he or she is going to give him close to the max on that desecration charge.
So Gene, so our audience understands, and each state is a little bit different, but generally speaking, there'll be a range with which the judge can sentence a person on any particular crime. And there'll be a range here, go on the low range and the high range. In Jersey, at least, and in many other places, what typically would happen is when a judge was sentencing, they used to go pretty much towards the middle of the range unless there were mitigating factors or aggravating factors that would cause them to either go less or go higher. And that was a general rule. Given that I believe that that's probably the general rule there as well, why do you think in this case, is it your opinion, that the judge will aggravate it to the higher level?
For a couple reasons. One, I have never seen a case of decapitation. First off, where's the head, Bob? He decapitated his father's head, and we don't know where it is. So that was unusual. And that shows premeditation, by the way. But the way he did it, and it's his own blood, it's his father. That is the most aggravating set of circumstances you possibly could have. And I do believe because he got acquitted, I think the judge is going to err on the higher end of the range to send a message. You can't do stuff like this. My goodness gracious. Where's your moral compass?
Right. Great points, Gene. And I would suspect we're going to hear the defense say that he has suffered so much trauma by the fact, I kind of flipped that to double-edged coin or on the sword there. He suffered so much trauma because he killed his own flesh and blood. He's living in a prison himself for the rest of his life because of it. It'd be very interesting when those arguments are made to see where the judge falls on this case. Again, sentencing will be tomorrow on the case, but we are Friday, I apologize, will be on Friday. We're going to do some work here at the Law&Crime Network, get a little commercial in here, and we're going to have more Gene Rossi. I got another guest, and like I said, we're going to be starting up at 12:30, hopefully with the Murr case, but you know that judge, maybe, maybe not. We'll be right back. Okay, Gene, so let's talk trial tactics here, because when you're going to cross-examine a defendant, seems to me you better have some real good firepower to be going with, as opposed to how many cigarettes did you smoke and where did you throw them and whatever. It seemed in this particular case, because of the nature of this witness, and each witness is different, you got to feel them when you're cross-examining them, know their abilities, know where to go to see if you can push buttons. This is a very calm defendant, which probably came off to the jury as being believable.
You know, when I taught all those baby prosecutors, one thing you don't do is you be a parrot. You don't use your cross-examination to just repeat the testimony of the defendant. The first question I would have asked this defendant, I would have said, Mr. Scandirito,
where's his head?
Look at the jury. Tell the jury, where is your father's head?
There you go.
And I would just sit back, and I don't care what he said, because they didn't prep him for that question.
You know, Gene, that could be a very good tactic. If you really don't have anywhere to go, don't be fishing, don't be repeating his answers. Do a Gene Rossi. Where is his head? I got nothing further, ladies and gentlemen of the jury. That could be an effective cross-examination. Let's listen to a little bit more of the prosecution's cross-examination of Mr. Scandirito. Okay, Gene, back to your point. I was paying particular attention to the point that you made. We use the term looping. When you're your own witness, you do this with your own witness, when you want to keep going back to that relevant testimony that's really important for the jury to hear, and you're asking a question with always using that central theme, getting back to it. The prosecutor here is just reiterating the story that he gave on direct, with the exception at the end of turning the phone off.
As I said, don't be a parrot. Don't just repeat. And I wrote this down, Bob. This is looping. You can use it during direct and cross. Sir, when you cut his head off, were you wearing gloves? When you cut his head off, did you have a garbage bag nearby? When you cut his head off, did you grab his nose or his hair to hold it? When you cut his head off, the jury would hear that phrase 50 times.
Right. So, Gene, what you just demonstrated to the audience, and that's why I love being on this network, and especially having guests like you, is whether you're a trial lawyer, a law student, a true crime buff, you both did a principle of looping there when you cut his head off. That's where you kept getting back to that central theme, so you can't be objected to because you're asking a new question all the way each time. And I agree with you that if I had nothing, and I can't say what he had in his file or he didn't have in his file, so I'll give him that break. But if I had nothing, I would have done the same exact thing you're talking about with the headpiece to show how gruesome it was. How much blood was getting on you? Was it slippery? What did it smell like? You know, get as much as you can in with that and then just sit down if you've got nothing else. Well, anyway, the great Gene Rossi always giving us the great tips as trial law nuance is very important in terms of winning and losing a case. We're going to do some business here at the Law and Crime Network. Go to a break. We got a lot left. I'll be here to 3 o'clock with Gene and yet another guest, so stick with us.